Welcome to the Deep Dive, where we slice through complex information, grab the most vital insights, and make you effortlessly well-informed. Today, we're plunging into, well, a really tough story, a real-life story of profound vulnerability, and a legal battle that didn't just seek justice for one person. It actually reshaped our entire understanding of accountability, especially, when public trust is broken. Our deep dive today focuses on the South African Constitutional Court case, NKV Minister of Safety and Security. Now, this case grappled with a really crucial legal principle called vicarious liability. That's basically a term for when one person or entity, usually an employer, is held legally responsible for the wrongful actions of another, their employee. Our mission here is to unpack this landmark case, make its facts, its groundbreaking legal reasoning, and its lasting significance crystal clear for all of you. Whether you're just curious about how justice works, or maybe you're deep into legal studies.
Absolutely. And this really is a pivotal case. It shows how fundamental constitutional values in South Africa can actually transform older legal rules, ensuring justice is served even in the most challenging, frankly, heartbreaking situations. It pushes the boundaries of what responsibility really means in a constitutional democracy like South Africa's.
So let's start with the night that changed everything for Mrs. NK. It was March 26, 1999. Miss K was just 20 years old, and she found herself in an incredibly vulnerable position. Think about it. 4 a.m., big city, stranded after an argument with her boyfriend at a bar. She was alone, trying desperately to call her mother from a public phone at a petrol station. But the phone wouldn't even allow outgoing calls. Just imagine that feeling.
Yeah, absolutely desperate. And it was right then, as she was pleading with the attendant for help, that a car pulled up. A policeman, Sergeant Nathaniel Ramatel, in full uniform, driving an official South African police service vehicle, he approached her. He offered Miss K a lift home. Now, put yourself in that situation. Alone, scared, 4 a.m., and a uniformed officer offers help. Naturally, she accepted. She placed her trust in him. What she didn't know, couldn't have known, was that two other uniformed on-duty policemen were also in the car, Sergeants Gabat Holwe and Nkwandela. She didn't know any of them.
They started driving seemingly in the right direction towards her home, but the journey soon took a truly terrifying turn. Mrs. K apparently fell asleep briefly, only to wake up as the car made a wrong turn. She immediately protested, "Where are you going?" Then, chillingly, a policeman's jacket was thrown over her head, held tight. She screamed, she kicked, she struggled for air as it was pulled tighter. She begged them to take it off. Her pleas were met with a sharp punch to her stomach. And a threat, an explicit threat. She'd be killed if she didn't stay quiet.
The car then stopped. Mrs. K was forced into the back seat, her jeans, her underwear, socks, shoes all removed. And then just horrifically, she was raped by all three policemen. In turn, she kept fighting, but it was futile. Afterwards, they put some of her clothes back on her, helped her out of the car, and just threw her on the ground, the jacket still held over her head. When it was finally removed, the three men got back in the vehicle and just sped away. A charge of rape was laid. And on May 25th, 2000, all three policemen were arrested, charged, and subsequently convicted of rape and kidnapping. They received life sentences for the rape and 10 years for kidnapping, and they are, to this day, still serving those sentences.
Facing this immense trauma, Miss K sought justice. She made the incredibly difficult decision to sue the Minister of Safety and Security for damages. Later, she actually dropped her claim against the individual policemen. I mean, realistically, they were in prison, unlikely to be able to pay any damages. And this decision really set the stage for the central, crucial question of this case. When police officers, sworn to protect, commit such heinous acts while on duty, is the minister, their employer, vicariously liable? Is the state responsible? Okay, so let's unpack this concept. Vicarious liability, what exactly is it? Think of it like this. If you hire someone to do a job, and they mess up, do something wrong while doing that job, you, as the employer, might be on the hook legally. It's an old common law principle, meaning law built up from court decisions over time, not statutes from Parliament. The employer is responsible for the wrongs, or delicts, as they're called in South African law, committed by an employee, but the key phrase is, in the course and scope of their employment.
Exactly. And the rationale behind this, it's sort of twofold. First, it's about ensuring victims actually get compensated for the harm they've suffered, especially, when the employee who directly caused the harm can't pay, like in this case. And second, it kind of incentivizes employers to be careful, to take steps to prevent their employees from harming the public in the first place. It does create a bit of tension, doesn't it? But the general idea that you're usually only liable for your own fault.
Right.
But society's decided over time that employers need to bear some risk here.
Right. But the real sticking point Where these cases always get complicated is what happens with a deviation. What happens when an employee goes off script, especially when they intentionally commit a horrific wrong something miles away from their normal duties. This was the crux of the issue the lower courts had to wrestle with in Miss Kay's case.
And wrestle they did. The Johannesburg High Court initially dismissed Miss Kay's claim, said the minister wasn't liable. Then it went up to the Supreme Court of Appeal, the SCA. They also dismissed her appeal. They essentially decided that, based on the existing legal principles of vicarious liability at the time, the minister just wasn't responsible. The SCA used what they call the standard test. They asked, was the officer's deviation, their wrongful act, so extreme that they were no longer exercising the functions they were appointed for? Were they still carrying out any instruction from their employer? Their answer was basically no. And crucially, the SCA explicitly rejected arguments to adapt, to sort of evolve this common law test in light of the new Constitution. It said providing compensation in such cases, well, that was a job for the legislature, for Parliament to sort out, not the courts.
And that's what brought Miss Kay to the Constitutional Court. This is where it gets really interesting constitutionally. Her legal team had three main arguments, but the pivotal one, the alternative argument, was this. Okay, if the existing common law test doesn't hold the minister responsible, then the test itself needs to be changed. It needs to be developed. They argued this development was demanded by Section 39(2) of the Constitution because the way the test was being applied just didn't align with the spirit, purport, and objects of the Constitution. It wasn't reflecting constitutional values.
And that specific argument, that focus on developing the common law itself, is precisely what made it a constitutional matter. It wasn't just about whether the facts fit the old rule. It distinguished it from an earlier case, Phoebus Apollo Aviation, where the issue was more about just applying the existing rule correctly. Here, Ms. Kay's lawyers were saying, look, this rule as it stands isn't just. It doesn't reflect the Bill of Rights. The court needs to bring it into line. That was the key difference. It opened the door for the Constitutional Court.
So what does this actually mean for how law should operate in South Africa? How does the Constitution interact with these older rules? Well, the Constitutional Court had already set a precedent in another major case, Carmichael v. Minister of Safety and Security. Carmichael established that our Constitution isn't just a set of rules. It embodies an objective, normative value system. Think of it like the Constitution acting as the country's moral compass. It has to guide and shape all areas of law, including these long-standing common law principles.
That's a great way to put it. And Section 39(2) of the Constitution is very specific. It says courts must develop the common law in two situations. First, if a rule directly contradicts a constitutional provision. Obvious enough. But second, and this is often more subtle, even if it doesn't directly clash, the common law must be developed if it falls short of the spirit, purport, and objects of the Bill of Rights. So courts can't just apply old rules mechanically. They have to be constantly alert, as the court puts it, to the normative framework of the Constitution. Always checking, does this law reflect our core values? Dignity, equality, freedom from violence, especially when the law is evolving incrementally.
And when you connect that powerful idea directly to Mrs. Kay's horrific experience, well, the profound constitutional importance of her rights just leaps out. Her lawyers emphasized her right to freedom and security of the person, specifically the right to be free from all forms of violence from either public or private sources. That's huge. They also pointed to her fundamental rights to dignity, to privacy, and to substantive equality. These aren't just abstract concepts. They're about the right to live safely, freely, with respect.
And this ties directly into the police's own duties. Section 205 of the Constitution spells it out. Their job is to prevent, combat, and investigate crime, to maintain public order, to protect and secure the inhabitants of the Republic. The Constitutional Court in that Carmichael case had already stressed how vital freedom from sexual violence is for women, saying it goes to the core of women's subordination in society. And they emphasized the police's primary role in protecting the public from violent crime. In Mr. Kay's case, the court explicitly said those comments from Carmichael were of equal importance here. The context was chillingly similar.
It's fascinating how the Constitutional Court really pushed back against this traditional view that applying vicarious liability was just a purely factual question. They argue that trying to treat it that way was like trying to sterilize the common law test, stripping away its inherent social and policy context.
Exactly. The court stated very clearly that this purely factual approach cannot be sustained under our new constitutional order. Why? Because these legal principles, they argued, are imbued with social policy and normative content. They're shaped by what we, as a society, consider fair and just. Pretending otherwise, the court said, just bedevils the exercise. It hides the real reasons behind the decisions. In an open democracy, you have to articulate your reasoning. So applying the rule isn't just checking boxes. It demands a moral and constitutional evaluation.
Okay, so to see how the law changed, let's quickly look back at how courts used to handle this. There was an early key South African case, Feldman v. Mall. In that one, a driver took a detour for his own reasons, got into an accident. Even though he was off script, the employer was still found liable. It shows how tricky this line drawing always was.
Right. And that line drawing evolved into what became known as the Minister of Police v. Raby test. This became really pivotal. It had two parts. First, a subjective question. Were the employees' wrongful acts done solely for their own interests? That's mostly factual. But even if the answer was yes, then came the second objective question. Was there still a sufficiently close link between the employee's acts, even if self-serving, and the employer's business or enterprise? And this objective part, the Raby Court said, is where constitutional values must come into play. We should note, though, that different courts applied Raby in slightly different ways over the years, which created some uncertainty.
And this whole challenge, figuring out employer responsibility for these awful deviations, wasn't just a South African problem, was it? Other countries were facing similar things.
Not at all. You see similar developments elsewhere. In the UK, for example, the case of Lister v. Hesley Hall. There, a school was held vicariously liable for a warden's sexual abuse of students in a boarding house. The court found the abuse was so closely connected with his employment, because his job gave him the opportunity and authority, that it was fair and just to hold the employer responsible. He abused the very trust inherent in his job.
Similar echoes in Canada, too.
Yes, very much so. Cases like Baisley v. Curry and Jacoby v. Griffiths, both dealing with the sexual abuse of children by employees of institutions. Justice McLaughlin in Baisley really focused on finding a significant connection between what the employer's enterprise did, the risks it created or enhanced, and the harm caused. She talked about looking at factors like, the opportunity the job provided to abuse power, the power the employee had over the victim, and the vulnerability of potential victims. Interestingly, Baisley found liability, but Jacoby, on different facts, did not. It shows that even with a clear framework, the specific circumstances really matter.
There was a U.S. case mentioned too, Primo v. United States, but the court here didn't find it that helpful.
Right. The Constitutional Court found Primo quite distinguishable. The officer there was off-duty, out of uniform, and significantly, the U.S. court itself was very divided, a 6-5 split, which kind of weakens its persuasive force anyway.
So what the Constitutional Court seems to be saying is that the objective part of the South African Raby test, that focus on sufficient connection, is actually quite similar to these international approaches.
Exactly. And crucially, the court found that the Raby test is flexible enough. It can incorporate our constitutional norms, provided we explicitly acknowledge and articulate them. It allows the test to be applied transparently, guided by the Constitution.
Okay, so let's bring all this back to Mrs. Kay. Applying this developed Raby test, now clearly infused with these constitutional values, how did this new lens change the outcome for her?
Well, the first part, the subjective test, was pretty clear-cut. Subjectively, yes, the policemen were acting for their own horrific purposes, not the minister's business, when they committed the rape. But as the Raby case itself established, that finding is not the end of the matter.
Right. And this is where the second leg, that sufficiently close connection and those constitutional values, become absolutely critical.
The Constitutional Court really zeroed in on three interconnected factors that together forged that sufficiently close link. First, the duty. The policemen, and by extension the minister as their employer, had a fundamental constitutional and statutory duty to prevent crime and protect the public. That's literally what they were employed to do. Second, the element of public trust. This was huge. The police offered help. Mrs. K, seeing the uniforms, the official car, reasonably placed her trust in them. The court emphasized that this trust, quote, harmonizes with the constitutional mandate of the police. Trust is essential for them to function effectively.
And the third factor?
The third factor was about simultaneous actions. The court found that the policeman's act of rape or wrongful commission occurred at the very same time as their failure to perform their duty to protect Mrs. K, a wrongful omission. They were on duty. They should have been protecting her. Instead, they harmed her. This simultaneous commission and omission, the court argued, created a very strong link back to their employment duties, even though they were violating them. The SCA had been mistaken to dismiss this line of reasoning.
Now, the minister's lawyers did try to counter this, didn't they? They brought up internal police rules.
They did. They pointed to a special force order that prohibited transporting unauthorized passengers. Their argument was, essentially, the officers were breaking rules, so the minister shouldn't be liable. But the court pushed back. They noted Mizzy K was stranded, or in die nude is, as the Afrikaans version put, meaning in need. She might well have fallen under an exception to that rule. And more fundamentally, the court stated that simply breaching an internal instruction isn't automatically a get-out-of-jail-free card for the employer. It's a factor, sure, but not decisive on its own.
And there was that really striking concession from the minister's side, too.
Yes, that was quite remarkable. The minister's legal team conceded that they would have been liable if Ms. K had been, say, arrested first and then raped while in custody. The court found this distinction completely absurd and, crucially, quite at odds with our constitutional values. How could it be okay to hold the state liable if they arrest someone wrongly and harm them, but not liable if someone trusts them willingly and is then harmed? That concession, the court said, really highlighted the untenable nature of the minister's overall argument. The opportunity for this horrific crime arose precisely because Mrs. K trusted them as police officers. Their actions were a direct betrayal of that trust and a simultaneous failure of their core duty. That created the intimate connection.
So weighing everything, the facts, the develops law, the constitutional values, the constitutional court reached its final decision.
Yes, a unanimous decision. The court declared that the minister is vicariously liable for the damages Mrs. K suffered as a result of the rape.
And the specific orders.
The judgments of the High Court and the SCA were set aside. The minister was declared liable. The case was then sent back down to the Johannesburg High Court, specifically to determine the amount of damages Ms. K should receive. And, importantly, the minister was ordered to pay Ms. K's legal costs for all the court battles, High Court, SCA, and the Constitutional Court itself, a significant measure of justice.
So let's pull back. What's the bigger picture here? What does this judgment actually mean for you, for the law, for society in South Africa?
Well, firstly, it powerfully solidified the principle that the common law isn't set in stone. It must evolve. It must be read and interpreted through the lens of the Constitution, especially Section 39(2), which insists the law must promote the spirit, purport, and objects of the Bill of Rights.
Absolutely. And it strongly reinforces the state's responsibility for what its employees do, particularly when those employees, like the police, are given immense power and public trust. If they abuse that position, the state can be held accountable. It also provides a critical pathway to a remedy for victims of abuse of power, especially something as devastating as sexual violence when it's committed by state agents.
And finally, it underscores just how vital the police's constitutional job is to protect the public, and how crucial public confidence is for them to do that job. When that trust is broken so violently, accountability must follow. The state simply has to answer for it.
So this tragic personal story really did spur a crucial legal development, fundamentally redefining employer liability and the public interest, all under the influence of the Constitution.
It leaves us with a really important question to think about, doesn't it? How does this ruling continue to shape our understanding of accountability, of trust, and of the state's fundamental responsibility to protect its most vulnerable citizens, especially when wrongful actions seem, on the surface, outside official duties, but are actually deeply intrinsically linked to the power and trust given by the state itself?
That's a powerful thought to end on. It's a question that continues to resonate and shape our society. Thank you for joining us on this deep dive into NKV Minister of Safety and Security. We hope you continue exploring these fascinating and often challenging intersections of law, justice, and society.